Hey everyone, welcome back. It is Michael with Offshore Citizen, and there's been something going on lately, which is there's a lot of noise about Facebook suing people, in particular suing the tool providers for affiliate marketers, in particular something called cloaking software providers. And people are writing to me about this and talk about how they're afraid, are they going to get sued for advertising practices, etc. And what are the consequences and other ways to protect themselves, etc. So we're going to expand our asset protection series by going really specific on issues such as this to hopefully give you some great information about what it is that you need to do to protect yourself from things like that. Now, what's really interesting in these particular cases is traditionally companies like Facebook and in general FTC and various celebrities, etc., will go after people inside the US. Okay, they're US companies, it's US court system, it's US laws, it's fairly straightforward. And in fact, literally to the point where if you were to go to the FDA website, one of the things that you'll notice is they provide a warning that they say, hey, be careful buying things from outside of the country because we can't do much to protect you in that case, which tells you a little bit about the FDA's ability to reach beyond the US. Now, there are plenty of cases we've seen. There's a very famous case in the world of internet marketing, affiliate marketing, a guy by the name of Jesse Wilms in Canada. This was back in maybe 2000 and, I can't remember, 2009, 2011, maybe something like that. And they ended up going after him. And, it was a big deal. He got, I can't remember, like a $450 million judgment against him or whatever the number happened to have been. And so certainly, and they ended up, he had kind of shell companies that were providing payment processing accounts in Cyprus, and the people who were providing, there was a whole big thing that went on there, okay? But in this particular case, Facebook has gone after a Hong Kong company, and I think it was December, there's an Indian guy, there's a bunch of different people, and so the conventional idea of how far it is that they can reach has changed. So first of all, I'll give you a little bit of background in terms of probably the reality in that situation, and then we're going to go into, what would people typically do in terms of structuring to protect themselves. All right, there's going to be 2 or 3 important sides of it to make very clear, and it's quite useful. And then, if you want specific advice, because there is a lot of technicalities about it, you can reach out to us and we can discuss it. Okay. All right. So first of all, probably just because somebody is sued doesn't mean that has deep consequences, right? In reality, when a company like Facebook sues someone, they're not necessarily, and they're probably not going after the money. Okay, this is quite different than if, say, we're doing a patent infringement lawsuit, where you probably do want royalties, you want money, you're a patent troll, and that's the objective. In this particular case, Facebook probably has 3 objectives. The first objective is simply to create some publicity noise, okay? Basically to scare people, so they try and decrease abuse of their platform. The second is to stop what is in this particular case a kingpin, right? So you basically have a cloaking software provider, and the cloaking software provider has a whole bunch of clients who are using it who are breaking Facebook's advertising rules, potentially polluting their platform. And by taking that one major kingpin down, they make it so that a whole bunch of others, supposedly or hopefully to them, go away. All right, so that's cleaning up their platform. And the third is making it a little bit painful for those, so that it prevents them from going and doing it again. Because obviously, what's to prevent someone from saying, okay, great, I'm going to shut down, I'm going to rebrand, I'm going to open up in a different company name, I'm going to open up basically the same software and do the same thing again, right? So they want to kind of prevent that. All right, so in that sense, when they come and sue somebody, they're probably not looking to go to court. They're probably looking for a settlement. The settlement is probably going to involve saying, okay, you're going to shut down, you're going to agree not to do it again. You're probably going to pay legal fees and maybe some minor amount of damages. It's probably not going to be a massive thing, but it's possible that they would go for something more significant, again, probably more for PR reasons and to make it painful than anything else. Okay, all right. So that's kind of the context. Now, in spite of that, there's no guarantee, like say they sued this company in Hong Kong, there's no guarantee they'll actually get anything out of that, right? Hopefully from their standpoint, like I said, they can achieve these objectives, but let's say they actually have to go to court in Hong Kong. Well, first of all, the court in Hong Kong would have to agree with them, okay? That some sort of a law was broken, etc. Obviously the terms of use, okay, great, but what how far can you take that, right? So that's the first thing, is they may not win. Even if they win, doesn't mean that they can enforce that judgment, or at least that it will cost them extra, be more hassle to enforce that judgment, etc. And that's kind of the next piece of it. And this is where we get into some of the nuances of what we're going to talk about here today. Okay, so the first thing, if you go back and watch our other videos on asset protection, I've discussed how, there's really the probability of having something happen to you, and then the severity kind of decreasing the consequences of if it happens to you. And there's two parts to reducing the probability. One is, flying below the radar, being a low-hanging fruit, having safe business practices that are not going to result in you being exposed to risk. The second is creating at least the appearance that it is much more difficult to go after you than it is worth. And I've seen this happen in a variety of different parts of the world where somebody would go to sue somebody else. The person may well be in the wrong, okay? I've seen cases where somebody is in the wrong, for sure. But the amount of hassle, say you're going after 150 grand, 900 grand, whatever, it's way too much hassle to go after that in this foreign country. Maybe there's a foreign legal system, it's maybe bureaucratic, maybe you have, it's another language, maybe the assets aren't necessarily there, et cetera, et cetera, et cetera, that make it quite difficult to go after that person. And so, they can hence get away. And there's other different layers of the process that can get built in there, okay? The third thing, as I mentioned, is reducing the amount of loss. And so we're going to get really specific here, okay? We're going to talk exactly about what it is that would end up happening in a situation like this. So the first thing is, obviously, as we've discussed, there's this subject of jurisdiction, and jurisdiction is super important. Basically, a U.S. court has only jurisdiction in the U.S., right? A Hong Kong court only has jurisdiction in Hong Kong. A Panamanian court has jurisdiction in Panama, and so on and so forth, right? So now you can get a judgment potentially enforced in another country, but you're going to have to go through a legal process. So let's say that you're in Hong Kong and I sue you in California. I may win in California, and then I have to go and try and get that judgment applied in Hong Kong, right? This is not necessarily an easy thing to do. It's certainly going to add expenses, it's going to add time, it's going to add difficulty. So it's going to make it more likely that they're A, just not going to go after you, and B, that they're going to be in a situation where, in addition to not going after you, they'll settle for less, okay? Now, related to this, you might say, okay, well, somebody may form a Hong Kong company and operate through that company, but they may be in the US, right? So what you'll see in some of these cases, there was a particular one, I can't remember what the companies were, but it was in a situation in California. The owners were named, all of their companies were named, et cetera, and they went and shut it all down, right? So this can certainly happen to you. And so part of the idea here is to minimize the risk of that happening, all right? So what is typically going to happen in a case like this? Well, first of all, of course, you're going to have a foreign entity. Ideally, you're not, in the country that you're going to be at risk. I often have said for years and years now that your assets are safest where you are not, okay? So having that separation, and in particular where your liability is not, okay? So if you're going to create issues in the US, if you're not in the US, the assets aren't in the US, this makes you much safer. If the liability is in UK, it's better that, you and the assets are not in UK, and so on and so forth, right? Just makes it just much safer. It's the way that it goes. So, okay, let's assume hopefully that you're not in, the US, Canada, some of these countries that it's going to be the authorities and the courts, et cetera, are going to be more likely to cooperate. And by the way, we're talking here typically about civil matters. If we're talking about extreme criminal matters, what I always tell people is, I'm like, look, if you're Osama bin Laden, none of this matters. They can and will get you, and so should they, right? So should they. There's no reason that you should be able to protect yourself, with layers of different corporations and trusts and things like that if you're a terrorist, right? That's not the idea here. The idea here is civil damages. This might be lawsuits, this might be divorce, child support, employee disputes, disputes with like suppliers, providers, etc., right? This is typically what we're talking about under there. And we're assuming, you didn't kill somebody. We're assuming that you didn't rob somebody. There was a case of a guy in Chicago who, was making all this money and running around bragging about it, etc. Well, basically what he was doing was he was stealing the money. Like, it was just outright fraud, right? Now, the definition of wire fraud is extremely broad, and so they can get you on that for many, many things, which, is a tool that they can utilize to go after you. When there was a famous case, it was called Black Friday. where 3 of the major poker companies that were primarily operating out of Costa Rica all got shut down. This was, I believe, in 2011. And anyway, so part of the thing that they got people on was wire fraud. There was a whole bunch of different charges depending on the company and things like this. It's quite an interesting case to study. But bottom line is, depending on how serious what it is that you're doing is going to, the tools at their disposal are going to be greater, such as do you have extradition agreements? Do you have mutual legal assistance treaties, et cetera, et cetera, et cetera. And these things are all worth recognizing and looking into. So one of the things that I mentioned to someone the other day was I said, if these people who Facebook was going after were in China or Russia, good luck. Like, what are you going to do? You're going to go to mainland China or Russia where A, there's no extradition treaties, B, maybe there isn't Facebook, C, they really don't care, and they're not going to be particularly cooperative. And then on top of that, if you have corrupt legal systems, especially if the guys have local connections, etc., you can look. Edward Snowden is hiding in Russia, right? If Edward Snowden, who they absolutely want far more than they're going to want you, is able to hide out in Russia, well, that tells you a little bit about the ability to hide out in Russia, right? And obviously, there's varying degrees. Roman Polanski obviously was convicted of, was it rape or wanted for rape, child molesting, something like that, and went and hid out in France, right? Interesting case. Probably shouldn't be allowed to, but that is the way that the way these rules work. Okay, so the bottom line is, when you're setting up here, you're going to have some sort of an operating entity. Okay. Now, that operating entity is designed to be the thing that takes the liability. Okay, so it is not going to hold many assets. Okay, it's probably only going to have operating capital. Ideally, the owners are not really connected to it. So first of all, you want some sort of nominees on there. You want hidden records. So it's harder to see what's going on in this particular case, right? That opaqueness, as opposed to transparency, is much better because you start looking. Now, this brings us to a legal/operational side, right? Because if you turn around and you say, okay, great, that's the operating company that's, let's say, being paid, but a domain name is registered in your personal name, well, now that's tying back to you, right? So we have operational factors, including, who's making decisions, who's signing agreements, who's signing off on, whose name or domain's in, what are addresses associated with it, what are phone numbers associated with it, what are office addresses, how are these things being paid for, are personal credit cards being used, etc. Like, there's all different things that could be used to tie any given individual to what's going on, right? And so best practices, that needs to be separated out, okay? Now, that's kind of operational, and operational can get really deep, which you'll see. Some people are paranoid in the messaging services they use and how communication happens and aliases and all this. And the truth is, the more aggressive someone is being, the more worthwhile it is to put those layers in between themselves, right? There may be an argument for, simply outsourcing and delegating certain things as opposed to being directly involved. Now, there's obviously business purpose sides of that, and whether it makes sense, that's a whole other conversation. Okay. All right. So there's this operating company. The operating company is taking on the liability. The operating company has some sort of nominees involved in there. That company is the one and that company is holding very little cash. What's the consequence of this? The consequence is, let's say, so hopefully the first thing with respect to the secrecy and the nominees and all that kind of stuff is that hopefully they cannot identify who the owners of that company are. They can only go after that company. That's your first objective. Ideally, they can only go after that operating company, okay? So let's say they go after the operating company. Okay, fantastic. Now, they do that, and at that point in time, you want to say, all right, well, first of all, it is harder to go after because it's in a foreign country, it's a foreign legal system, it's more expensive. Ideally, it's not connected to what it is you're doing. Now, if you're concerned about Facebook or something like that, they have pretty long reach because they operate all over the world today, right? But that being said, this is the deal. Okay, so there's that company. Now, if it gets sued, and in worst case it loses, and in worst case they're able to enforce that judgment, if there's only, say, $50,000 in the company, well then the amount that they can get is limited to $50,000. The company can be bankrupted, and that's that. What would they do in that case? They would try and pierce the corporate veil, right? They would try and go beyond that company to where did the money go, right? And this is going to lead to two different kind of a binary path, right? The one is there's a holding company. So the traditional way that it used to tend to be done was you would have an operating company, which was owned by a holding company, which was held in trust, okay? And so wonderful, you've got this holding company and you have to pierce the corporate veil to get there. Now, especially if that holding company is in a separate jurisdiction from the operating company, it makes it harder to pierce the corporate veil because you don't have the continuity of a court case, right? If you say, okay, hey, we won this court case here, we have this judgment, we've enforced this judgment, we believe that the owners of, or the directors of, this other company, basically there's an alter ego here, and you can watch our video on the corporate veil, is responsible. So if you're kind of carrying that through in the same court system, that's easier than if you have to go to a separate court in a separate country and basically go through the whole case again, right? Say, hey, and with the added burden of proof of demonstrating that we need to pierce the corporate veil, okay? So now you say, okay, again, it's more expensive, it takes more time, etc., to go through there. If you're in that situation, then again, there's still the same requirement to enforce that judgment, okay? All right, now let's assume for a second that you're in a situation where they do identify the ultimate beneficial owners, the directors, the people involved, etc. Well now, and you can go back and watch our earlier videos about asset protection, you go in a situation where you're like, okay, they can go directly to the owners and they can come from the back, right? They say, okay, great, we're gonna name the owners, we're gonna name their companies, we're gonna name everything, we're going after all their assets, etc. This is a problem, right? So this is where trusts come in, okay? And by the way, so I mentioned this holding company thing. The other way is to have a parallel company, right? So there's a service provider that provides. In my view, having a parallel service provider company adds an added level of defense. It's a little bit harder to trace, okay? It's a little bit harder to prove in a sense because you now have to prove that, hey, it was a service provider that was somehow responsible for this, rather than, especially when you're talking about small companies where there's maybe only a few people involved, it's easier to say, hey, look, they're actually responsible because they were the ones who were making these decisions, right? So, okay, great. So parallel company, you can still get through it, but, maybe a little bit tougher, although both can work, okay? All right, so now you're in a situation where you have to pay attention to trusts. We have, again, videos on trust. You can go and take a look at it. I'll elaborate more in some other videos on details of asset protection, trust, etc. But that being said, there's some sort of a trust. Now, what is this trust going to do? This trust has two fundamental functions. The one is, say they attack and win a judgment against the owner of this structure or this company, the person who's involved, right? Now that person's assets are exposed, right? Well, now what they're going to say is they're basically going to say, hey, here's my assets, I don't have many, and that's that. And they're going to say, well, hang on, what about these other assets? You can say, no, I don't own those. Those are held in a trust. They don't belong to me. So my liability doesn't go there. And the best that I can do for you is I can write a letter of wishes. This is, a discretionary trust that's irrevocable, like I can write that, but you're going to have to go after them. And now there's a much, much harder ability to pierce that trust shell. Now, we can get into the Statute of Elizabeth and fraudulent transfer rules and things like this. I talked a little bit about that when we were talking about the video of how to choose the right trust jurisdiction, etc. So that's something to discuss separately. But the bottom line is you have quite a bit of difficulty going after those assets in a situation like this, right? Especially if it's been set up for a while, because you can kind of have these limitations on what that time period is, okay? So what do we got here? The fundamental is we have an operating company, we have a holding company. Now, it used to be that what we would typically say is we'd say, hey, the trust then owns that holding company, okay? That was kind of the old paradigm, and what you would often see, at least certainly kind of what we would work on with clients, was this structure. I think it's a little bit more refined to actually have the trust separately, because then the assets can come from the holding company and then be put into trust, which is kind of a separate thing, right? Now you're like, okay, it's a little bit tougher to work your way around what's going on there. But that's kind of the basics of it, okay? Now, whether the trust is parallel, whether the trust owns it, the important thing is you have at least 3 layers, right? You have the operating company layer, you have to litigate there, you have to win, then you have to enforce the judgment, then there's going to be a bankruptcy. Then you go to the holding company level. Holding company level, you have to go through the same thing again, whilst piercing the corporate veil. Then, to go beyond that, you either have to have gotten to the owner and say, hey, look, the owner is a part of this overall case, is a big block, or you have to say, hey, look, the owner is, basically we're piercing the corporate veil yet again to get to the owner. Now again, you can put a trust in there as a barrier, and then you can say, okay, well the owner is separate, and then we have to pierce to the trust, and the trust is separate from the owner, right? You can do it that way. Or you can turn around and you can say, okay, hey, there's a trust off to the side, and you have to pierce it that way. And there's varying arguments for where the strength is going to be in those particular cases. In a perfect world, what we historically used to say was, we said the ideal is to use a separate jurisdiction for every one of those things. So we say, okay, yeah, there's the operating company in one country. It has a bank account in country B. Then the holding company is in country C. Then the holding company's bank account is in country D. Then the trust is in country E, and the trust's bank accounts are in country F. So you have 6 jurisdictions to pierce, right? Very, very difficult to do that. Extraordinarily difficult. Now, the challenge with this is that banking has gotten so complicated and so challenging that you're going to have a good luck trying to get bank accounts in all those different countries, and especially maintaining good quality banking in the process, and especially if you're flowing quite a bit of money through there. So a little bit debatable in terms of whether that actually makes sense to structure it that way. But that being said, this would typically be the structure that you would want to apply, and then where the nominees are, where the trustees are, etc. All those nuances you would have to play with. But if you kind of maintain these things, right, you say, okay, great, I have a good operational process. I have an opaque structure that is somewhere abroad, and I have these layers of protection between me and the liability. You're going to be in a very tough spot to go after. It's probably as close, provided that the nuances of the trust are structured properly, provided that, again, all the details of this, and the details are really important, right? I've mentioned before, I think, don't go and buy a $2,000 trust. Make sure that it's properly created for your situation. We can get into details about, the types of things that might be used to penetrate the trust. One of the key things here, I'll mention kind of the last thing, is sometimes what can happen is the assets are in the trust and maybe they can't get to the assets in the trust. But what they can do is they can prevent you from getting to the assets in the trust. So you have to design it in such a way that the assets are accessible while at the same time protected. And these two things are quite difficult to maintain. As somebody pointed out, it's not hard to protect money from someone. You can just donate it to charity and it's gone. But it's not accessible to you. So it's having it accessible to you while protecting it, which is extremely difficult. Okay, so anyway, that's the high level of what's involved. It's super nuanced, and even just like a typical trust agreement, I would say should be 40 to 80 pages long if it's properly authored and things like this. It takes a bunch of weeks to draft. There's lots of detail you have to go into pertaining to the law and the potential liabilities and how it's managed and who's involved, and is there a legacy piece to it, and what about if something happens to someone, and in the event that this happens. And so anyway, I'll do some other videos on protectors and investment managers and things like this and different roles in trusts. But for now, this is the main thing. So anyway, if you're interested in that subject, reach out to us. Check out offshorecitizen.net, offshorecapitalist.com. Email me, post in the comments. Hopefully this was informative to you. Like this video, subscribe, and I will see you guys on the next video.